Welcome one and all to today's Humanities in Action event. My name is Max Storm, the Executive Director for Carolina Public Humanities, and it's always my pleasure to welcome you to Flyleaf Books. The true sign of civilization in any community is a fully independent and functioning bookstore. Yay, Flyleaf Books, let's put our hands together. Flyleaf Books has always been a wonderful partner in a lot of our programs, and we're so happy to be able to run this series and other events here at Flyleaf Books, including our great books, reading groups, and other wonderful special events. I want to thank our sponsors, the Cotton Merker Group and Morgan Stanley, who have always been so generous in supporting our K-12 programming. We want to thank the North Caroliniana Society, who have been very fundamental in funding our teacher workshops, including our North Carolina Bill Friday teacher workshop. We certainly want to thank the Carolina Meadows, a retirement community at Chapel Hill, who have been a long supporter of our public programming, and of course our partners in putting on programs, the General Alumni Association. So thank you to our sponsors and partners, and I know Paul is dropping information on all of those organizations into the links there. I also want to thank our staff, of course, Paul Bonici, who has transformed himself into a Zoom broadcaster extraordinaire. So thank you, Paul, for all the work you're doing, making sure that you folks out there can get access to our great content. I want to thank Vicki Breeden, who does so much logistical work on all of our programs. And I want to ask for a warm welcome to Destiny Lee over there. Hi, Destiny. Our newest colleague at Carolina Public Humanities, who's helping man the floor here. So thank you for all of that. We really appreciate it. Very briefly, I want to explain Carolina Public Humanities for anyone out there who doesn't know who we are and what we do. We are the public outreach arm for the College of Arts and Sciences, and it's our job to make sure that excellent scholarship and faculty at Carolina are shared with as many communities in North Carolina as possible. We do that through an extensive outreach with community colleges throughout the state. In fact, we'll be going to Robeson Community College tomorrow, and we'll be in Wayne Community College on Monday. So it's one way we make sure bringing, again, excellent faculty and scholarship and sharing it with as many people in North Carolina as possible. I've given you some sense in my opening and thanking our sponsors that we also have an extensive K-12 outreach program called Carolina K-12, and that work is absolutely essential in making sure that our public school teachers have as much information on hand to bring to their students and, of course, share humanistic knowledge and dialogue and reflection with them. And of course, public programs like these here, many of which happen in Chapel Hill or in surrounding Triangle communities, including our flagship program, our weekend seminars, and I'm just going to put a plug up for some upcoming ones very quickly. This is The Greats. Alexander and Catherine the Great is a dialogue seminar coming up on October 30th, and we still have room for that if you're interested in attending virtual or live. We, of course, have wonderful series, Lunch with Friends and Strangers. There's only one more of these coming. This is a virtual series we started during the era of COVID. It's a biography series, and our final one will be very special because we're going to have live music with pianist Robert Buxton, who will be talking about two wonderful African-American composers, William Grant Still and Florence Price. So that'll be a performance and biography discussion online, and that is October 29th. And then finally, of course, this series, the series that really defines our relationship with Flyleaf Books, is the Humanities in Action series, where we look at hot button topics, issues that need, again, dialogue and reflection in the community. And we've had a really great series talking about Afghanistan, misinformation in science. We've looked at seeking truth in an age of distortion, social democracy, social media and democracy. And now we get to today's topic of critical race theory and the law. Next week, we will have another wonderful, our final series will be actually our colleague, Christy Norris, who I believe is out there in the ether. Hello, Christy, who will be coming and talking about the incredible work that she and her colleagues are doing, teaching hard history, those topics that are difficult to teach, and working with our North Carolina teachers to understand how to navigate a lot of issues that become more filled with passion than information often. A couple other public programs I'd like to mention. On October 26th, right here at Flyleaf Books, we have North Carolina, Land of Water, Land of Sky, the new book by Bland and Ann Simpson. This is a virtual and live event at 6 o'clock on October 26th. And we will have information on that being dropped into our virtual chat box there. And of course, you can find that information on humanities.unc.edu as well as coming to flyleafbooks.com. And finally, on November 5th, we have an NAACP community read The Devil in the Grove by Gilbert King. This is again a virtual program from 6 to 7 on November 5th. And Paul will be dropping some information in on that. And of course, come and visit our website if you want more information, humanities.unc.edu. Yeah, critical race theory. This is something that I've seen just any number of conversations on Facebook posts and makes me want to just scream that people need more information about the origins of critical race theory, what it actually means, and how it's actually practiced. And we have UNC's expert on that with us today. Erika Wilson is Professor of Law, the Wade Edwards Distinguished Scholar, Thomas Willis Lambeth Distinguished Chair in Public Policy, and the Director of Clinical Programs at the UNC School of Law. Professor Wilson's expertise is in civil law, civil rights and discrimination, education, poverty, and public interest law, and of course, critical race theory and race in the law. This is why we brought her here today. Product of the University of Southern California, Wilson later attended the UCLA School of Law, where she received her JD in 2003. After working at Arnold and Porter and as the George P. Lindsay Staff Attorney Fellow for the Lawyers Committed to Civil Rights, Professor Wilson joined the University of Baltimore School of Law and came to Carolina Law faculty in 2012. In addition to publishing scholarly work such as The Great American Dilemma, Law and the Intransigence of Racism, The Legal Foundations of White Supremacy, Charter Choice and White Flight, Gentrification and Urban Public School Reforms, and New School Segregation, among many other titles in distinguished law journals. Professor Wilson is also an engaged public scholar whose work has been featured in Al Jazeera, Vox, Wall Street Journal, and other national and local publications. Being here today is another testament to Professor Wilson's commitment to public service, and we're so thankful. So without further ado, please welcome Professor Erika Wilson.
Thank you all for coming out today, and I am delighted to be able to talk today about critical race theory. As I'm sure you're all aware, it is certainly a hot topic in the public discourse, this term critical race theory. And so what I want to do today is that I want us to have an open discussion, and so I should confess up front that I tend to be a little bit more interactive, so I might ask you to raise your hand or nod your head if you've heard certain things, because I think it makes it easier for us to dialogue that way. So the subject of my remarks are really about critical race theory and the law. And so that's an important distinction because we've heard a lot about critical race theory in the public discourse. But the reality is critical race theory originated amongst legal scholars. And so to really and truly understand what critical race theory is, why it is important now, and why it was particularly novel at the time of its origins, it's important to ground it in the law. And so that's what I'm going to do here today. I'm going to talk about three things generally. The first thing we'll talk about is what critical race theory is, and I also like to say what it is not. It's really important to deconstruct some of the misinformation about what critical race theory is or is not. Then we'll spend most of our time talking about the origins, the genesis of critical race theory, and looking at its application to law and how the use of these critical race theory frames gives us a different tool to analyze and understand the law and its implications. Lastly, we'll talk about why critical race theory is important as we think about furthering our democracy, particularly given where we are situated as a country right now. So, to get us started, I will talk about what critical race theory is not. So I told you up front that I would be a little bit interactive. How many of you have heard of critical race theory? Just raise your hand. All right. How many of you had heard of critical race theory before 2017? So fewer people, right? And so the reality is that critical race theory has been around since the early 80s, I would say, tab as the origins. But in the last 5 years, let's say, a slow build, critical race theory has slowly begun to enter the public mainstream dialogue, the term critical race theory. And so one of the ways that we've heard about critical race theory or that it's been framed in the public dialogue as some really, really bad and scary thing, right? And so one of the things that we've seen lately is that school systems across the country are enacting legislation to ban what they are calling critical race theory. Um, the way it's been framed in that public dialogue is that critical race theory relates to teaching white people that they are bad, teaching people that white people are perpetual oppressors, teaching people that black people are forever underdogs, you name it, a long list of misinformation about what critical race theory is. I love this picture on the screen, right? Because another really important way in which misinformation about critical race theory has been weaponized is through the youth. And I want to submit that that's not unintentional. We see the picture here of the little girl, a little white girl, holding up a sign saying, "I am not an oppressor," right? And so one of the things that I lament about the way that critical race theory is being introduced to mainstream people is that it is being introduced in a way that makes it seem like it is something that wants to do evil or bad. And when we situate that with children in particular, it gets really scary. And so much of the legislation, right, has suggested that critical race theory distorts history. I think there's a lot to say about the way in which it's been dovetailed with the 1619 Project, which, to be clear, and professor now, Nicole Hannah-Jones, would acknowledge that what she was doing there is not critical race theory. So there's an important distinction, right, between what's happening now or attempts to change or to delineate the ways in which we can teach about race and history. A lot of these bans are suggesting that we can't talk about race in certain ways or can't talk about certain historical facts in particular ways, and that's what we're being labeled as critical race theory. And so one thing to keep in mind is that when we talk about race in particular, in America, we've crafted a narrative of the way that race has functioned and the way that the law in particular has come to either free us from racism at best, or at worst, is sort of a neutral referee to make sure we all play by the rules. And so narratives are important because they give shape to how we filter or try and make sense of what's going on around us. And so we create narratives to explain a lot of what it is that we see in front of us. So when it comes to race, one of the narratives that we've told in the United States is one of traditional linear uplift, that we had this really bad period that started with slavery, and slavery was a function of the fact that people really didn't understand, or they were people of their time who did bad things and treated people differently because of the color of their skin. Then the narrative continues to suggest that we finally got it right after a civil war and decided it wasn't right to keep human beings in bondage, and we emancipated slaves. And then we had this other really bad period where people were treated differently because of the color of their skin. But then we had a Civil Rights Act, and then we got over it, right? This linear uplift story about race. One of the reasons why critical race theory is so controversial is because it forces us to rethink that narrative. It gives us a different sort of glasses, so to speak, to make sense of what it is that we are seeing. Because the narrative suggests that we've had emancipation, we've had laws put in place to prohibit discrimination, but we're still seeing deeply entrenched racial inequalities. I think COVID really blew open the door to allow us to see how bad it really is. But many of us, like myself, who study race, have known it's really bad for a long time. But after George Floyd and COVID, I think more people are starting to realize how deeply entrenched these issues are and how bad it is. And so where am I going with this? I'm going with this that it's not a coincidence now that critical race theory has been miscast, right, in a way that suggests it's some kind of boogeyman, mainly because the narrative that's been told has served a particular function to legitimate the status quo. This always makes my law students uncomfortable, so I'll make you uncomfortable now and tell you the story. So one thing I often tell my law students is that when we walk in our building in the law school, right, what we see in law school is a graduate program. I don't think I would get much contestation if I called it an elite gateway to a particular kind of living or existence, right? When we walk into the law school, what we tend to see is the majority of the students and faculty are white. The majority of the people in support roles, whether it is cleaning staff, other support staff, are people of color, whether that's African American, Latinx, some form of Asian, people of color, right? And the narrative that we've told ourselves about that helps us to be okay with it, to not really question and suggest that the reason that exists is because of a particular form of merit, that some people earn this and other people haven't worked hard enough to earn it, and that's just what it is. And so George Floyd, COVID, all of those things made people start to question that narrative a little bit. It pushed us a little bit, and critical race theory has been around, but it's a convenient scapegoat to attach onto, because there are people who benefit from the racialized status quo that exists, and critical race theory again becomes a convenient boogeyman to get us to not abandon the narrative we've had and continue forward with that narrative. So the last thing I'll say on narratives, because it's important to get this to understand why there's been so much misinformation, is I have a 10-year-old son, right? And so for all of his life, I've told him that there's a Santa Claus, and that Santa comes and delivers presents, and it's so great and it's so nice. He's now getting to the age where he said, Mom, is it true that there's really a Santa? And he asks me this at least like once every 2 weeks at this point. And I kind of hedge and haw, and I can see how upset he is to abandon that narrative, right? Because it made him feel good. It made him feel happy, right? And it made him make sense of what happens at Christmas. The idea that the linear narrative that I started with is not true, for many people is like telling my son that Santa is not real. Hopefully he's not watching this or won't watch this, but that Santa is not real. And so that is why we see things like these bills banning teaching of divisive topics, or situating critical race theory as putting the little white girl as the oppressor. So that is not what critical race theory is. And it's important to understand that the attacks on critical race theory are not new. The two images on the slides, the first one shows an article that's derisively called "The Bloods and the Crits." It's from a 1996 New Yorker article that talks about critical race theory. It says that it's an academic movement that's gaining increasing currency across the legal academy, rejecting the achievements of the civil rights movement of the 1960s, right? Situating critical race theory as rejecting that linear uplift story, right? And it suggests that scholars argue that the dismantling of the apparatus of formal segregation failed to purge American society of its endemic racism. So that part is a really important part of what critical race theory actually is. It does help us to look at systemic racism and help us to make sense. It gives us new lenses to understand what it is we're seeing, to formulate more appropriate narratives about why the world looks the way it does and the role of the law in creating that, right? But you can see the 1996 article cast this as a bad thing. I suggest Google it, The Bloods and the Crits, read it, and it reads very much like what we see today. Then 25, 30 years later, we see similar attacks. Ted Cruz says critical race theory is as racist as Klansmen and white sheets. So the point I want to make is the attacks on critical race theory are not new. They have always been there, and they are there because, again, it uproots the narrative that we've told ourselves about race and about race in the law and the way the world exists. So now you might be saying, well, Professor Wilson, you've told me what it isn't. Well, what the heck is it? Okay. And so what critical race theory is, affectionately called CRT, it's a theoretical framework. It is, again, if you think of the use of glasses or lenses to see a narrative, It's a framework that was developed by legal scholars to help us understand both legal and non-legal problems related to race, inequality, and power. Again, it is a framework that helps us resituate that linear narrative that most of us have been told and ingested all of our lives. The frameworks acknowledge that there is a constitutive connection between race and the law. This probably is the most controversial part of critical race theory, that it suggests that not that the law is some great savior that has come to ameliorate irrational problems of racism, but instead that the law is foundational to creating race and racism. And so this, again, is a complete 180 from the way that most of us have been taught about the role of race and certainly the role of the law. The frameworks that CRT offer are important because they help us understand how structural and racial disparities endure. Again, this narrative, linear narrative, has told us that after the Civil Rights Act, we were getting better, we're going to continue to get better, but that's not what's happened. In fact, in some ways, we've gotten worse, right? And so CRT gives us the frames to understand why that is. So whenever someone talks about critical race theory, if you remember nothing else from this discussion, it is a framework. That's what it is. That's the shorthand answer. It's a framework that we can use to analyze problems of race, inequality, and power. And so to really understand why these frameworks matter, the framework matters, and why it is particularly useful in the law, I want to spend some time talking about where it originated and how it originated. So one of the things about critical race theory is that it arose out of a conversation in the legal academy between progressive scholars about the role of the law in creating inequality. And so on the slide, I have Professor Kimberly Crenshaw, who coined the CRT term intersectionality, one of the founding scholars of the movement, right? And she says that one might say that what nourished critical race theory and facilitated its growth from a collection of institutional and discursive interventions into a sustained intellectual project was a certain dialectical misalignment. Within the context of institutional and discursive struggles over the scope of race and racism in the 1980s, significant divergences between allies concerning their descriptive, normative, and political accounts of racial power began to crystallize. This misalignment became evident in a series of encounters, institutional and political, that brought into play a set of misunderstandings between a range of individual actors and groups. So what she's talking about here is that within the legal academy, there are other progressive scholars, and I'm going to highlight one group of scholars called individuals who study what's known as critical legal studies. And these scholars analyze the law more critically. There are a couple of basic premises in the law that we've come to accept. And I should back up here and say this is important because the law gives order to society. It structures our society, and so understanding the role of law is extremely important, and the way that you view how laws come to be then matters for what the implications on the ordering of our society. So these critical legal studies scholars, affectionately known as CLS versus CRT, suggested some pretty controversial things at the time. One of the things that a normative baseline understanding of the law is that the law is coherent, that the law is free from politics or other kinds of political values like that the law yields determinative results. Those are three bedrock principles of how we as lawyers are taught to understand the way the law functions. So again, the law is coherent, it produces determinate results, and it's free from politics or other kinds of value preferences like that. So this other group of scholars, called, again, critical legal studies scholars, contested that. They suggested, no, that's not really true at all. And so the intervention that they bought into it was one in which they contested the role of the law. And so I'm highlighting for you an example of their contestation of the role of law through their critique of rights. And so when I say rights, what I mean is both the positive and negative rights that we've come to love so much. The right to be free from search and seizure, right, the Fourth Amendment. The right to the freedom of speech, the right to equal protection under the law. That's what I mean by rights. So CLS comes along and they upend those three bedrock principles of what the law is supposed to be through their critique of rights, amongst other things. What they said are that, first, legal rights are not as useful in securing progressive changes as we think, that we tend to look at rights and the freedoms that they bring as what has pushed our society forward in terms of making it a more fair and just society. And so CLS scholars said that's not really true. In fact, what we call legal rights are not what has gotten us the progressive changes that we've gotten. Instead, there are other things that have gotten us that, such as organizing, political pressure, violence, a lot of other things other than rights have got us there. They also said legal rights are indeterminate and incoherent, contrasting what I just told you earlier about the law supposed to be coherent. They say they are indeterminate and incoherent. Not only that, they're subject to manipulation, that they can be manipulated in ways that favor the privileged classes. And so one example I like to give of this to my students, right, is, well, two actually. We can see it now with the mask, let's say, discussion, right? I have this right to be free from oppression and not have to wear a mask, right? The way that rights can be manipulated in ways that favor a particular result or status quo. My favorite example is the way that rights have been used to attack affirmative action. This idea that I have a right to equal protection under the 14th Amendment means that institutions with long histories of racial discrimination and subjugation cannot attempt to remedy that by being more inclusive in their admissions policies, because then they are infringing upon my rights, right? And so we move from the 14th Amendment being used to protect traditionally marginalized groups to being used as a tool to reinforce and reify the status quo in ways that favors the already privileged dominant groups, right? So that's an example of what the CLS folks mean by rights are indeterminate and incoherent. One really interesting critique is that it reflects and produces pernicious forms of individualism. Rather than thinking about the collective good, what rights does is it puts us in a silo and it makes us think about my right to do this rather than our collective good and what's good for all of us. And I think there are a myriad of examples where we might see this today with the pandemic, right, in terms of the focus on individual rights and what it means for potentially the detriment of the public good or collective good. Lastly, they suggested that rights can impede a progressive movement for genuine democracy and justice. And so what they mean by this, and my apologies to CLS scholars out there because I don't want to completely miscast this, I'm going to put a little bit of my spin on it, I'll concede, is what they mean by this is that in some ways we get satisfied with individual victories, right? I have the right to do this, and we don't think about pushing and challenging the status quo more broadly in ways that would completely upend our structures and make them truly amenable and accessible and helpful for everyone, right? We are atomized in ways, rights atomize us, and they keep us from fomenting a revolution to completely change the way that we live and exist. And so this is what CLS scholars affectionately believe about rights. And so many of the CRT scholars said, hey, we're with you, but you're missing a few things, right? The CLS scholars are CRT scholars' allies. Many CRT folks were in the CLS camp. They agreed with many of these critiques of the law. But they did have some quibbling about the critique and its lack of understanding of the reality of the way that race functions in America in particular. This is because one of the consequences of the CLS critique hits directly on anti-discrimination law. I'm going to go back a slide and say, how many of you, just show of hands, if you buy 2 or more of their critique of rights, if you think generally their critique, at least 2 of them, sounds about right to you? Right. So most of us think that at least 2 or more sound right, right? So if you buy the CLS, at least half of the CLS critique of rights, it has very real implications for how you might think about anti-discrimination law. Anti-discrimination law, when I say anti-discrimination law, I'm really referring to the body of rights that we got as the result of the 1964 Civil Rights Act, the way we interpret the 14th, 15th Amendments to the Constitution, anti-discrimination law. That body of law is predicated on a belief in the value and validity of rights. It is predicated on the idea that we're going to achieve progressive social change and inclusion through rights-based discourse. We're going to give people certain rights or articulate certain rights, and that's how we're going to get along this linear uplift narrative. CLS scholars, however, would apply almost all of the same critique to anti-discrimination law that they do to legal rights discourse generally. They will say that anti-discrimination law actually has been not so great for us in terms of when we think about what could have been. It's actually been more important for legitimating existing class and race relations than it's been for ameliorating racism and discrimination. They would probably suggest that the individual atomizing and siloing on individual rights has enabled some portion, let's say, of African Americans to ascend to upper middle class, wealthy, but for the collective majority of them has been not so great, right? It really hasn't uplifted their plight, and that we missed the boat in some ways in terms of what could have been, that the reliance on rights as the baseline for anti-discrimination law is inherently flawed and has not done what we think it has done. And so CLS scholars also would then suggest that we have these hierarchies that exist, and anti-discrimination law hasn't got us to the place of disrupting those hierarchies. And so when I say hierarchies, I mean hierarchies on the basis of race and class. I think it's fair to say that many CLS scholars would more focus on the class aspects, or at least the class aspects of these hierarchies. But an important point of divergence, if you go back to Professor Crenshaw's quote or misalignment between who would become CRT scholars and CLS scholars, was the way the CLS scholars situated or failed to situate race. CLS scholars cast doubt on the utility of using race or race consciousness as a frame through which to understand and deconstruct the hierarchy. They maybe wanted to deconstruct it more from a class perspective, I think it's fair to say, and that they situated race as something that's ancillary. So, for example, African Americans are subjugated because they are poor and they're not in the elite class. They didn't centralize the because they're black part, is one way to say it. CLS scholars also embrace liberal notions of discrimination framed around bias and colorblindness. So CLS scholars didn't really have a structural understanding of racism, but instead adopted a framework of racism that suggested that it's illogical, it is bad treatment because of your race, and that it is something that is abnormal and anomaly can be fixed with education. And if we just all are colorblind, all of that will go away. If we just treat everyone the same, it will go away. And they question approaches that framed hierarchy in terms of institutionalized racial power. The why are you always talking about race approach to thinking about hierarchies. What CLS scholars did favor was more of a political transformation, a reordering of the state's relationship to people as a method of disrupting hierarchies rather than anti-discrimination law. So CLS scholars would suggest that our solution is political rather than rights-based. We should organize, gather together, and as a collective people push to reorder the relationship between the state and us, right? And I think it's fair to say that many CRT scholars would not disagree that that could be an effective means of attacking hierarchies. What the CRT scholars did disagree was that the CLS scholars' critique of rights in particular failed to address racial domination, particularly the hegemonic role of race and racism in creating existing hierarchies. So for the CRT scholars, they would suggest that race is not an ancillary thing. It's the main thing. It's why these hierarchies look the way they do. It's not that these hierarchies exist and that Black people happen to be more poor, so they're at the bottom of the hierarchy. No, they're at the bottom of the hierarchy because it was intentionally constructed that way around notions of whiteness as property and Blackness as a permanent form of subjugation. One of my favorite responses actually is that it doesn't account for their critique on rights doesn't account for social and transformative value of rights discourse in the context of racial subordination. So what does that mean in plain English? It means in plain English, CRT scholars suggested that race and racism are so fundamental to the ordering of our society that even though the rights-based discourse doesn't get us all the way there, there's a really important humanizing element that rights-based discourse gives us. So for example, one example I like to give is that my parents grew up in the Deep South, right? And so when I was a kid, whenever we would go on a trip, I lived in Nevada, we would drive to LA, they would pack up all this food. And I'm like, dude, what are you doing? We're just like a 4-hour trip. They pack up a lot of food. And one of the reasons they did that is because when they traveled through the South, they were not allowed to go into certain restaurants, get food, use the restroom, etc. And so there is a dignitary value that rights-based discourse provides for marginalized groups, African Americans in particular, that the CLS critique of rights neglects to realize, right? Given the hegemonic role of race and what it means from a humane perspective, the CRT scholars would suggest that there is great social and transformative value of relying on rights to upend this form of social racial subordination that marginalized groups face that you're missing. And lastly, I gave that personal example because they would suggest that CLS discounts the lived experiences of people of color, right? The lived experiences of people of color is telling us something very important about the way that race is functioning and what rights does to their experience that the CLS critique of rights is missing. And so this all matters because it is from this I guess, divergence with scholars in the legal academy that critical race theory began to foment as a sustained intellectual body. It began to push legal scholars and eventually develop to other fields to really resituate the role of race in the analysis, and for them, particularly in the legal analysis. And so one of the things that CRT gives us, right, one of the fundamental frames that it gives us is that race is socially constructed, lacking in any grounding in biological fact or meaning. What do I mean by that? I mean that there's no race gene that makes me Black or makes someone else white. Instead, race is entirely whatever we make it to mean. We set the rules for who's a particular race and the conditions upon which they are going to exist as a result of being raised in a particular category. I like to show my students this picture because both of these individuals are raised as Black, right? The young boy with the darker skin is Black, but if you just saw the little girl, you might raise her as white. But back in this time period, due to laws regarding hypodescent, she is raised as Black. And so this is a good example of race being socially constructed, not having any grounding in biological fact or meaning. And so another good example of the social construction of race is our racial wealth gap, right? CRT would say this is a prime example of race being a social construction. We've attached so many rules and privileges to the race that one is a part of. What has developed is a hierarchy that tracks racial lines. There's nothing, and so the graph here that's depicted shows the racial, the amount of wealth by race, and it predicts it in the United States out through 2024. And what we see is that the blue line depicts whites, and whites have a median household wealth of 102,000 in 1983. It's gone up and then down, and it predicts out to a median household wealth of 122,000 by 2024. The other two groups on the chart, Black and Latino, Black folks have a median household wealth of 6,883. It's projected to go down to 1,233 by 2024. So it's going down, not up, right? That also disrupts this linear uplift story. And same for Latinos, starts at 4,083, goes up a little bit more than African Americans, but it's still at 1,633 by 2024. So what's the point of this? The point is that there's nothing inherent about someone's race as white or race as Black or Latino that makes them more deserving, let's say, of having a median household wealth in the 100,000s, or less deserving to have it be only over $1,000. Instead, the rules that we've attached to race in terms of who can have access to certain things and who can't is what has caused this social construction of race and the consequences thereof. CRT also importantly does not define racism the way we would typically do it. So another interactive question for the group: how many of you throughout your life have conceptualized racism as not liking someone because of the color of their skin, or someone being treated badly because of the color of their skin, or the Klan showing up in white sheets, right? That's what we tend to think about as racism. So critical race theory certainly accepts that as a viable definition of racism, but much of its theory is actually premised on not that kind of individual racism, but more institutionalized racism. Racism that is the normalization and a legitimation of an array of dynamics, historical, cultural, institutional, and interpersonal, that routinely advantage whites while producing cumulative and chronic adverse outcomes for people of color. Again, I like to give for my students the example of the LSAT. All studies show that the LSAT is not all that greatly predictive of how well you're going to be a lawyer or your grades, but we continue to use it even though we know that many of the things attached to it, like who can afford to buy a prep class, who has had certain foundational educational experiences, are going to advantage whites and disadvantage African Americans, right? But we continue to use it, and we accept the normalization and legitimization of an array of dynamics, like walking into the law school and most of the Black people being in a role of service and most of the white people being students or faculty, right? Normalization, we've just accepted that. It doesn't have to be like that, right? Is how CRT would situate racism. Also, a system of hierarchy and inequity primarily characterized by white supremacy, the preferential treatment, privilege, and power for white people at the expense of people of color, right? So CRT's definition of racism is more of a structural one and not so much focused on that individual dislike animus one. And so that is the origins of CRT, right? It came as an intervention to other critiques of the law and said, hey, we need to think about the way race is functioning here. And here's how they suggested that race is functioning when it comes to the law in particular. It gives us this framework to understand, the relationship between race, racism, and the law. It helps us to see that the law is not just a remedial tool for addressing racism as discourse post-Brown versus Board of Education suggests. What do I mean by that? We've come to see, again, the law as at best a savior, something to save us from ourselves, to reorder the way that we relate to one another, to stamp out that kind of individual racism I talked about earlier. At worst, is just some kind of neutral referee. But CRT suggests it's neither of those things. CRT would suggest, to continue my sports analogy, that race is actually the quarterback or the point guard. It's sort of dictating what happens, who gets the ball, when, where, and why, right? These are the frames that CRT gives us to see about race. It helps us to see how the law both created race, racism, and continues to further racism today, again, relying on the structural definition of racism that I provided. So the role of law in creating race, right? One thing that I always like to emphasize and want folks to remember is that race and the social construction in America, for the most part, began with the enslavement of Africans, right? And so we don't tend to think about this think about it like this, but I said earlier, the law orders our society. It gives us rules and meaning and sort of dictates how we are going to function. Well, slavery was a legal status. There were laws, and I've got an example for you, that suggested that that all children born of any Negro or other slave shall be slaves of their fathers for the term of their lives, right? It goes further to say, as much as freeborn English women, forgetful of their condition, to the disgrace of our nation, marry Negro slaves, their kids are going to be slaves, right? So here is where we have the law intervening to give social meaning to race. If you are raised as Black, you are going to be a slave for the rest of your life. And so slavery was a legal status. It is from there that we first get meaning to race. It pays to be one race and not another. And so throughout, the law continues to do this. Show of hands if you've heard of the prerequisite cases. Okay, good. I always like to teach about this because many people haven't heard of it. Well, not good, but a good learning opportunity. So one thing a lot of people don't understand is that people used to go to court, just like you would go to court for a contract dispute, and go to court and seek to have the judge enter an order saying that you are white. So from this very premise, whiteness had a very important piece of value, right? And the reason they did that was because, I'll go back to the prior slide, there were some people who went to court to be adjudicated white because they didn't want to be enslaved. So they would actually sue and go to court and say, I'm not a Negro, I'm not Black, I am white. Judge, find me white so that I don't have to be a slave. And that is one function of what the law did. In the law, there are many cases where the court said, you are not white. Really interestingly, the court's opinions never say what white is. They always say what it is not. So whiteness is defined by exclusion. There's no list of what it takes to be white. Instead, just sort of, your hair looks like this, common knowledge, scientific, you're not white. And so the prerequisite cases in particular were related to immigration. Another way that the law functioned is that the first Immigration and Naturalization Act of 1790 by text limited immigration and naturalization to free white people in the text of the law. So these cases represent individuals who were trying to come here but needed to be adjudicated white in order to do so. And so you see Andre Yup is one of the more famous ones, 1878. The court held that those of Chinese descent are not white, so you can't immigrate here. They did it for a number of races. Native Americans are not white. Syrians are white, right? And so the opinions are always really interesting to parse through and see what they rely on to make a determination of who is not white. In this case, they said they are white. Japanese are not white. I wanted to highlight the Enrique Cruz case because it also wasn't just about being adjudicated white. It was also about being adjudicated not Black, because along this spectrum, right, whiteness being the highest value order that you could get, blackness was the lowest value order that you can get. Even other groups of color didn't want to be considered black. So in the Cruz case, we had a Native American person, someone who was mixed with Native American and African, going to court to get an order saying that they are not African, they're not black, they are Native American. And so this becomes an important distinction because rules of hypodescent usually say if you have one drop of black blood in you, you are black. But in this case, for Native American, they said the 3/4 trump that, you're Native American. And so more likely to give that designation to a non-white person than they would to give anyone with any African blood a designation of white. And so the big picture here is that here is a clear example of the law constructing race and giving meaning to it, right? And so again, critical race theory, go back to the CLS critique, is saying, you're crazy. You cannot look at this and not understand the role that race plays in these things and the role that the law played in constructing race. In addition to constructing the notion of race itself, the law also played a pivotal role in creating racism. Again, going back to the prior definition of racism, structural racism that I used. One case that I always like to highlight is the civil rights cases of 1883. So a little history on this is that after the emancipation of enslaved Africans, there was this period of Reconstruction, right, where there was an attempt to integrate formerly enslaved Africans into American society. And so one of the problems that the formerly enslaved ran up against was many forms of private discrimination. Innkeepers wouldn't let them into certain places. They were prohibited from being on certain forms of transportation, a long laundry list of things. So what Congress did was that they attempted to pass or to have the 14th Amendment of the Constitution. Remember, the 14th Amendment says that everyone's entitled to equal protection under the law. It is probably the most used and famous form of federal constitutional protections in terms of race and rights. But they tried to have that interpreted to say that private entities, businesses, could not exclude or discriminate against African Americans. They could not keep them out just because they're black. And so the civil rights cases of 1883 is a combination of 5 cases where individuals sued, arguing that they'd been discriminated against under the 14th Amendment. And the court consolidated all of these cases into the civil rights cases of 1883. And what they ultimately found was that the 14th Amendment is not going to be read to prohibit private discrimination, that there is no problem with private businesses discriminating against African Americans. The 14th Amendment can only be read to apply to the state when there's state action. In the instance of private businesses, there is no state action, so there is nothing to be done about this. Private businesses can do whatever they want and exclude whomever they want. One of the quotes that I pulled for you that I like to emphasize, because we hear a lot of this still today in today's Supreme Court and a lot of our judges. Keep in mind, this is 1883, a little under 20 years after the emancipation. So the majority opinion said, when a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of the state, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be a special favorite of the laws, and when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. So this is shortly after emancipation. You have the Supreme Court saying that, you know what, formerly enslaved, you've got to stop trying to be the special favorites of the law. You need to stand up and be treated like a regular citizen and have your rights protected like a regular citizen. Stop crying to us because private businesses are trying to exclude you. You're not special, and the government is not going to protect you. This is in 1883, right? Some of this sounds like it might have been written today, and you can see a similar discourse in some of our Supreme Court majority opinions these days today. And so the point I wanted to make with this is that, again, the law gives us order, and so the law here is telling us how we're going to not only restrict the reading of the 14th Amendment, but through this, which is essentially what's called dicta, telling us how we should think about attempts to get the state to intervene and to make sure that previously enslaved Africans are treated fairly and able to integrate into society. The other case I wanted to highlight comes shortly after Plessy v. Ferguson. Show of hands if you've heard of Plessy v. Ferguson. Good, most of you have. And so I actually put a picture of Mr. Plessy here on the slide because Mr. Plessy, if we saw him today, we might think he's a white man, right? But this is Homer Plessy, who was attempting to sit in the white section of a train car and was arrested, denied the ability to do that. And he sued, suggesting that the separation of the races is unconstitutional, violates the 14th Amendment. And so we all know that the Supreme Court in Plessy versus Ferguson said, no, it does not, that we can still afford equal protection of the law by allowing separate and allegedly equal, but it was never really equal, right? So here is really where post-emancipation, the law is playing a critical role in developing the kinds of racism that we continue to see today. But I wanted to highlight for you not the majority opinion, but the dissenting opinion. Justice Harlan's dissenting opinion is famous and often misquoted. It's often cited for the proposition that I bolded: our Constitution is colorblind and knows neither nor tolerates classes among citizens. But the part that people never talk about is what he said before that. He said the white race deems itself to be the dominant race in this country, and so it is in prestige and achievements and education and wealth and power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to principles of constitutional liberty. But in the view of the Constitution and the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. In respect of all civil rights, all citizens are equal before the law. Why did I want to highlight this language for you? Because on the one hand, he's saying our Constitution is colorblind, but on the other hand, he's suggesting that there is an inherent social order that will always exist, no matter what the law does or does not do. And so we don't need separate but equal in order to enforce this social system, because the natural order of things is that whites are superior and they're going to continue to be that way. I wanted to highlight that for you because this whole idea of the Constitution being colorblind often comes directly from Justice Harlan's dissenting opinion, but people never they don't do the whole assignment. They never read the whole dissent and what he says there and the implications of that, which again gives more credence to CRT scholars' supposition that race continues to be a driving force, integral in the way that law operates, the way that our discourse operates, even when we have the court saying that our Constitution is colorblind. And so we had this period of Plessy, the civil rights cases, where there are really direct, obviously racially antagonistic laws towards non-whites. But I wanted to move more to modern times and what critical race theory, the lens critical race theory gives us to understand what's happening now. So even in the absence of race-conscious laws that are intentionally treating African Americans different, what we have now and have always had are race-neutral laws that have a race-conscious effect. What do I mean by that? Critical race theory scholars would suggest that it's not enough just to look at the text of the law. You have to look all around and understand the context. The Social Security Act of 1935 is a good one, right? We had this act that finally gave us retirement income, but intentionally excluded agricultural workers and domestic servants who were predominantly African Americans. So it's an example of how a law can be race neutral, meaning that there is no overt distinction on its face, but still have intentional disparate outcomes. And we saw this a lot during this period, the New Deal period in particular. We saw it with the Social Security Act. We also saw it with something called the Wagner Act. The Wagner Act granted unions the power of collective bargaining, which was really important for labor rights, but it didn't contain explicit anti-discrimination provisions, which allowed blacks to be excluded from unions for a long time, and therefore excluded from better paying jobs. So CRT gives us this lens to understand how it is that race functions in the law, either explicitly or implicitly. And so a really important lens that CRT gives us is it helps us to understand why we still see the things that we see today in terms of like the slide I showed you with the racial wealth gap. That story of linear uplift I told you about suggests that in 1964, we had the Civil Rights Act of 1964. Show of hands if you've heard of the Civil Rights Act of 1964, right? And so it gave us a law that prohibited discrimination in key areas of life like employment, housing, public accommodations, etc., right? I pulled the newspaper from that time period that had the list of things that the Civil Rights Act would prohibit discrimination in. But despite that, one of the important things that the Civil Rights Act did is that it just said you cannot discriminate on the basis of race. It prohibits discrimination on the basis of race. The thing it didn't do was to afford any kind of reparatory relief for the centuries of discrimination on the basis of race that occurred before then. It's like driving a train and you just stop and you don't try and fix any of the damage the train did along the way. You just stop the train and make a right and drive better, right? It doesn't really fix the harm that was done before. In terms of the law, a lot of anti-discrimination laws are undergirded by a normative commitment to anti-differentiation. What do I mean by that? The law suggests that we can end racism and discrimination by simply treating everyone the same. Don't discriminate, no longer see race, right? The problem with this is that a commitment to anti-differentiation in the law has led judges to situate affirmative action as the moral and legal equivalent of Jim Crow segregation, right? It is not a realistic assessment of historical conditions and ongoing subordination. It says that any distinction on the basis of race is automatically bad, and Jim Crow segregation is the same as affirmative action. And maybe there are people who, not maybe, there are people who are committed and wedded to that understanding of the way the law should operate. CRT scholars suggest there's an alternative to that. And so one of the outgrowths from the anti-differentiation principle is what we know as colorblind ideology, which is rife throughout the law. Adirondack versus Pena is a famous affirmative action case where the court outlawed the use of affirmative action programs in construction, federal construction grants. And so Justice Thomas's concurring opinion has good language that exemplifies the colorblind logic. And he says, in my mind, government-sponsored racial discrimination based on benign prejudice is just as noxious as discrimination inspired by malicious prejudice. In each instance, it's racial discrimination, plain and simple. So again, they're both the same. The anti-differentiation principle leads us here that they're both the same thing. Then we see it further today, right? Parents Involved, a voluntary school integration plan that Seattle and Louisville, Kentucky tried to implement. Justice Roberts, writing for the majority, struck it down, saying, you know what, the way to stop discriminating on the basis of race is to just stop discriminating on the basis of race. Don't see race and treat everyone the same. That's the way the law should handle this. Lastly, the colorblind ethos in the law gives race to a post-racial ideology. It suggests that Shelby County is the famous case that gutted the Voting Rights Act. And in that case, the majority opinion suggested that the Voting Rights Act provisions that required pre-clearance before changes to voting systems were implemented was no longer necessary because the previous the numbers showed that racial minorities are not being stopped from voting because racism is no longer a problem. We've handled it. There are no longer disparities. And so for the non-lawyers, a little technical, but the bigger point here that I'm making is that anti-differentiation gave way to both colorblind ideology and post-racial ideology. And so that is the lens through which the law is viewed now. What CRT gives us is it suggests that we should step away from anti-differentiation and embrace something called anti-subordination. This is a key example of a frame that critical race theory gives us that many people might take issue with, right? An anti-subordination frame would suggest that the law should reform institutions and practices that enforce the secondary social status of its historically oppressed groups. That rather than being committed to anti-differentiation, we should be committed to anti-subordination, that we should be committed to ensuring that there is not a dominant and subjugated class that exists along the basis of race and is very much tied to past historical conditions. It suggests that the anti-differentiation commitment precludes much of the work of anti-subordination. We can't get to anti-subordination if our legal analysis tells us that Jim Crow is the same as affirmative action, right? It's not realistic given the historical construction of race and the work the law has done there. Because of that, gross racial disparities exist. Unless and until we can get to anti-subordination, we are not going to undo the patterns of racial disparities. That story of linear uplift when we get to the Civil Rights Act is a false narrative, and it's not going to ever be an honest and real assessment unless and until we do some work of anti-subordination. So I want to leave some time for questions. So I'm going to close with explaining why I think that critical race theory and the frames that it offers us, both the way it situates race and racism and its relationship with the law, and the way that it leads us towards anti-subordination rather than anti-differentiation is not only important but necessary for furthering democracy, right? I often tell my students, if you frame the problem wrong, you're going to probably get the solution wrong too. So a lot of what we've seen, I think, post Civil Rights Act is that we framed the problem of race and inequality wrong. We framed racism again as some abnormal, I don't like you because of the color of your skin, individual animus, and we formed the issue of racial disparities that exist around certain pathologies. Black people are poor because they don't work hard. Black people's schools are bad because they don't value education, right? We are loath to look at the more structural realities, and CRT pushes us to do that, to look more at the structure, to understand why these disparities persist, and not only persist, but continue to get worse. So I suggest that that kind of analysis is necessary for the health of our democracy. So I intentionally put up a picture on the slide of the January 6th events, because I think that is maybe the most visceral and real recent indication of how tethered our democracy is. Our democracy in large part depends on citizen belief and the legitimacy of institutions, certain institutions, political, financial, educational institutions. At the same time, our democracy is increasingly more racially diverse. We are seeing a broadening of the racial dynamics of the entire society. And so as we continue to see this, it is going to be more challenging for us to engender legitimacy in all of our institutions if we continue to have these gross racial disparities across the board. Some examples, for example, is that one of my favorites to show is that it suggests that recent study said that racism costs the U.S. economy $16 trillion because of discrimination, right? So I suggest if you haven't seen this study, Google it because it's really fascinating and eye-opening study. And so part of what I'm suggesting here is that if we continue to frame the problems of race and racism incorrectly, we're going to continue to get headlines like this, right? Racial disparities in home appreciation, studies showing that African Americans have a hard time building equity in their house because they are often likely to have an appraisal that is substantially less if the appraiser knows that they are Black. That African Americans are completing college at a lower rate, a lot of it related to issues of poverty, etc. But the bottom line is, as long as we continue to have these headlines, it's going to be hard for us to have a feeling of legitimacy in these institutions. When you have a disaffected population, it's hard to have a thriving democracy. We must therefore develop the will and capacity to recreate our society so that it no longer perpetuates the lie of white supremacy or capitalizes on Black subordination. Legalized racial subordination and degradation has fundamentally shaped every American institution in ways that make our institutions vulnerable. We again saw that on January 6th. CRT gives us the analytical tools to name what is happening and frame appropriate solutions to address these problems. And so that is my pitch for why CRT is not only important, but necessary for the health of our democracy. So I end it with 15 minutes left.
Great. Thank you so much, Professor Wilson. What we'll do now is we'll take questions. We invite people who are online to put questions in the question and answer button at the bottom of the screen. But I will start by offering, and I think Sam Jackson and, okay, Bruce both have a question here.
I agree that CRT is a wonderful analytical tool to dissect what is going on. I'm curious what process it offers in terms of remediation or in terms of prescription. How might one get to an anti-subordination outcome? Through what mechanism?
Yeah, that's a really good question. So I think CRT offers a couple of thoughts on remediation, right? Reparation, so to speak. The first is to acknowledge that rules related to anti-differentiation are counterproductive. The most obvious example of this is race-conscious admissions policies, which are quite controversial. This idea that we are going to take into account race when making decisions as to who gets into elite institutions, right? An anti-subordination perspective advanced by CRT scholars would suggest that race-conscious admissions policies are not a form of pernicious racial discrimination against whites or Asians, but that instead it is a small correction for a system that is inherently built on advantages for whites, affluent whites in particular. So one example, right, in the admissions process, in the lawsuit at Michigan, it came out that if a student lived in a particular zip code, they got more points in the admissions formula than they did for being an underrepresented minority. It turns out that that zip code that got all of those points was like predominantly white. If they were a legacy, they got all these points in the admissions process. Well, given our history of discrimination, who is more likely to be a legacy, right? These kinds of advantages that are baked into the system that are effectively racial advantages for whites that we don't name or claim like that because they operate invisibly. So enacting course corrections like a race-conscious admissions program is one example of how we would get to anti-subordination. The other, right, is more obvious, and that is some kind of economic form of reparations, race consciousness in terms of housing, remediation for discrimination that's happened in housing in terms of the New Deal and ability or inability of African Americans to capitalize on the New Deal, being race conscious and thinking about the kinds of lending programs we might offer, or even general reparations, right? These are a few examples of how we might get to anti-subordination.
Great.
We had a comment that was an earlier sort of comment in the chat about the emphasis on education, and I think that that'd be one place. Do you believe that funding of education is another way of an anti-insubordination policy?
Sure, it wouldn't hurt. I always like to say that education is really important. It's a bedrock issue in terms of trying to right the ship. But I want to also be clear here that education alone isn't enough, right? That we should definitely enact more equitable school funding, for example. But just education won't undo the racial wealth gaps that we see or many of the racial disparities. The disparities are too deeply entrenched. It has to be education plus other things. But I 100% think that we should be thinking more about anti-subordination in the context of school funding and school assignment. One of my areas of study is actually race education and the law. And one of the points that I often emphasize is that what is happening now is affluent whites are able to monopolize the highest educational opportunities through race-neutral laws. Things like where you go to school, school district boundary lines, very much track race and wealth. A school system like Chapel Hill, right, very much tracks race and wealth. And why do we need a Chapel Hill school district when we live our lives regionally? I live in Durham. Today I crossed 3 different counties to get to work. We could draw this differently, but we choose not to. So that would be another example of anti-subordination, abandoning practices that we know are going to favor a shallow subset of people and disadvantage the already marginalized amongst us.
Okay, Bruce, do you have a question?
Well, actually, you took my question, but I have a different one. Historically black colleges and universities, I have trouble deciding whether they're part of the problem or part of the solution. I'd appreciate your thoughts on that.
Yeah, and I wish my husband was here, but he just left. He went to a historically black college, and so I think historically black colleges are a wonderful part of the solution. It's another example of how commitment to anti-differentiation might lead us down a road that takes off the table a really helpful and useful tool. The reality is HBCUs produce more black college graduates than any other institution. Most of our doctors, lawyers, other black professionals are HBCU graduates. As long as we are dealing with long sordid history of racial discrimination, entrenched systemic racism, HBCUs will always play a valuable role in terms of being able to address black students in ways that are different than what they might get at a predominantly white institution in terms of a certain level of educational support, community, high quality education, the whole 9. I should also add that I think that the historically part of black colleges and universities, when I go down to North Carolina Central Law School, it's almost 50% white, I think. So I think there's a place for HBCUs, not just with black students, but with all students in terms of the experience it can provide and the function it can play in terms of helping us to what's the right way to say this, to better know each other, to build better social bonds than what we currently have.
If you'll humor me a question, I'm going to take this somewhat from my Facebook threads. There is a tendency to sort of allied, as you had mentioned, like the 1619 project with CRT, and you've done such a great job in a public forum like this, sort of letting us know what the limits of CRT are and how they work. But we know that society, as you've told us, is made up of these structures. These structures are defined by the law, but it's also defined by ideas and practices. And many people would say a critique that I've heard of CRT is that the ideas, even Enlightenment ideas and practices such as capitalism, are in and of themselves racist, and therefore are part of the problem. And you need to tear it all down. And that's when we get into this idea that CRT is coming for the very essence of the society. How do you delineate those ideas and at the same time accept critiques of ideas and practices?
I mean, I've definitely heard that one too. This idea that, especially capitalism, right, is rooted in racism, and that CRT takes a scorched earth approach. And so, what I do say to that is that CRT and the ideas that it promulgates are not going to tear down this society that is hundreds of years in, right? That what CRT offers is a way to look at the big picture, but also to look more locally, as how I like to put it, in terms of things that we can do on a smaller scale to get to a place of better inclusion and more fairness, right? That argument is very similar to the argument about the abolish the police movement, right, or abolition movement. None of those things are happening tomorrow. Both are ideological interventions that attempt to help us think about how we could structure some things different and build towards a better world. And I think to the extent that we shut those ideas off or don't at all take them seriously or miscast them, as CRT has been miscast, and we are doomed to continue to follow an ill-fated path. I hope if January 6th taught us nothing else, it's that this is unsustainable. We cannot continue on this trajectory and continuing to believe the Santa Claus narrative about race is not going to fare us well in the future. I think there was a good report that came out that said that racism is a national security threat. It's really important that we have these frames to think about a different route to go. And I do think it's also fair that you can critique CRT. Honest intellectual critiques of CRT are legitimate. One thing I should have said at the beginning is that even within CRT, there are divergences and differences of opinion about different frames, right? And that critical race theory is not, it's not myopic, it's not static, it's dynamic. It continues to evolve as well. And so that is another response, I think, to this idea that it's going to take a scorched earth approach and burn it all down. It's a dynamic theory, and it can be useful, not just useful, but I think it's imperative for us to consider these frames as we think about how to actually get to a linear uplift model, because we're not there now. And I think the idea that you got to burn it all down is a dangerous form of fear mongering.
Okay, we have a question here.
Yeah, I'm sure you've heard of what recently happened in Johnston County with the county commissioners.
No, I have not heard about that.
The county commissioners in Johnston County withheld school funding
Oh, right, yeah.
until the school board agreed
Yeah.
that they would not allow certain CRT instruction or something like that.
Yeah.
Where was the law?
Yeah, I think that is quite dangerous, right? I think that there are potential First Amendment issues there. There are also potential ways that the federal government could get involved in terms of withholding federal funds in order to stop that kind of behavior. I think there are also probably state and local government laws that could come to bear in terms of stopping that kind of power play as well. It's really disheartening that that is happening, and I think there's a role for lawyers to play in particular in terms of being willing to challenge these things. There's also a role for parents to play in terms of being able to speak out against that kind of power play. These are local government officials who have to be accountable to a populace, but I'm really especially concerned about potential First Amendment issues. Although my First Amendment scholar friends would tell me it gets complicated, but I still submit that there are First Amendment issues there.
You might imagine we've had a lot of First Amendment discussions in the last Humanities in Actions that
I
we've done
bet.
with all the topics that we've had. I invite any other questions online and in the room. I do have, I think you've sort of addressed this, but one person wrote in the chat, why are we focusing on elite institutions when we should be focusing on educating the pool of folks from childhood on so that they'll be competitive and not need lowered admission standards?
Well, so I would address that two ways. First, they're not lowered admission standards. I think if we approach it from the idea that implementing a race-conscious approach to admissions means that we're admitting less qualified people, that's not true. The very idea of qualified, who is or is not, is also socially constructed in ways that favors certain classes of people. That's the first point I would make. The second point I would make is that I would actually agree it's important that we consider just not elite institutions, but all institutions. The reality, however, is that these debates tend to happen at elite institutions because that is where most of the push is in terms of where you're going to have pushback about race-conscious admissions, the institutions that are using more myopic admission standards. And so it's also the place where we tend to have a gateway issue in terms of UNC, for example, right? It's the flagship state university in the state. And so going to UNC holds a certain amount of cachet, and that's why there is more contestation there. But I'm totally on board with the idea that we should be trying to educate all, and that we should be paying attention not just to the elite institutions, but all of our public institutions.
We're at the end of our time. I have one chat. I'll just ask if you agree. Do you think that standardized tests should be done away with for admissions?
Yes.
Yes, okay, good. I think that kind of addresses the comment in the chat. Let's put our hands together for Professor Erika Wilson. All of you out there, you can hear there's, in addition to the room, there are many more clapping in their homes right now. I will just come up and say goodbye to all you folks up there and remind you that next week, our dear friend Christy Norris will be taking a look at teaching hard history in K-12 education from politicization to reconciliation. Christy Norris is a force of nature with our North Carolina teachers, so come and check that out. I'm going to bring you back into camera one more time to say goodbye to everybody. Please put your hands together one more time for Professor Erika Wilson. Go to humanities.unc.edu and check us out. Thank you so much.
Thank you for having me.
Great. Have a good evening, everyone.
you.
Bye-bye.